A daycare center, 3-year-olds, hand-painted cartoon murals on a cinder block wall in Hollandale, Florida. And Disney sued them. Not sent a strongly worded letter. Sued. Because somewhere in Burbank, California, there is a legal division so aggressive, so relentless, and so effective that entertainment lawyers openly call it the most feared legal team in America. This isn't a rumor. This isn't internet exaggeration. This is a company that has sued the Academy Awards. A company that sued underground comic book artists into bankruptcy over a 2-page drawing of Mickey Mouse doing drugs. A company that, in 2025 alone, dragged one of the biggest AI companies on the planet into federal court and won the opening battle before it even really started. But here's the twist nobody talks about. This same legal machine, the one that has crushed mom-and-pop Etsy shops and multi-billion-dollar AI startups alike, walked into a fight with the governor of Florida and lost. Badly. So, which is it? Is Disney's legal team unbeatable? Or is their reputation bigger than their record? By the end of this video, you're going to understand exactly how Disney built the most feared legal department in corporate America. The real cases that built that fear. The billion-dollar fights happening right now, and the one opponent that finally beat them at their own game. Stick around, because case number 3 involves a small business owner who ended up a household name for all the wrong reasons. And it happened just a few years ago. To understand why Disney's lawyers are feared today, you have to go back to 1971, to a group of underground cartoonists in San Francisco who called themselves the Air Pirates. Led by an artist named Dan O'Neill, the Air Pirates set out to do something nobody had really tried before. Take America's most wholesome cultural icons, Mickey and Minnie Mouse, and turn them into foul-mouthed, drug-using rebels in an underground comic called Air Pirates Funnies. The goal was satire. The goal was to expose what O'Neill saw as the fake, sanitized image Disney had built. Disney did not find it funny. On October 21, 1971, Walt Disney Productions filed suit, alleging copyright infringement, trademark infringement, and unfair competition. What followed was one of the longest, strangest intellectual property battles in American legal history. O'Neill kept drawing. Disney kept suing. Nearly 10,000 copies of a single printing were seized by court order. In 1975, Disney won a $200,000 preliminary judgment, and O'Neill just kept going, defying the restraining order again and again. The case dragged on for the better part of a decade before the courts finally sided decisively with Disney, ruling that even parody has limits when you're copying the exact visual style of a copyrighted character. Legal historians still study this case. Some argue it set the boundaries of parody law for an entire generation of cartoonists. And one law professor later said the whole saga set parody back 20 years. That's the kind of gravitational pull Disney's legal team has always had. Even when a fight is legally murky, Disney has the resources and the will to fight it for years, until the other side simply runs out of money. That's not a courtroom skill. That's a war of attrition. And it works. Fast forward to 1989. The year Disney's reputation as a legal juggernaut became permanent. That year, the Academy Awards opened with a bizarre, campy musical number featuring an actress dressed as Snow White. Disney had not approved the use of its character. So Disney sued the Academy of Motion Picture Arts and Sciences, the organization that hands out the Oscars. Yes, Disney took on Hollywood's own governing body. That same year, Disney's legal team also went after 3 small daycare centers in Hallandale, Florida, demanding they remove hand-painted murals of Disney characters from their exterior walls. These were murals meant to comfort toddlers, painted by well-meaning local artists, and Disney's lawyers treated them exactly the same way they'd treat a counterfeit merchandise ring. The message was unmistakable. There is no use of Disney intellectual property too small, too sentimental, or too sympathetic to escape enforcement. That posture never really went away. Fast forward to the 2020s, and the pattern is identical, just with different targets. In 2020, Disney won a lawsuit against a Florida retailer called Mouseprint Media, also known as DizGear, for using copyrighted lyrics and images from Star Wars and Frozen on unlicensed merchandise. In another case that made national news, a small Florida couple, David and Marisol Chaveco, who ran a modest party supply business, found themselves facing a Disney lawsuit, seeking $1 million in damages. A local party shop, $1 million. And in 2023, Disney sued two Kissimmee-based online sellers, a husband and wife operation doing business as Sparkling Dreamers, for continuing to sell unauthorized Mickey ears, magnets, and keychains, even after receiving multiple cease and desist letters. Disney's attorneys don't view these as minor nuisances. They view every unlicensed keychain as a crack in a legal wall that has to hold everywhere, or it doesn't hold anywhere. That's the philosophy that makes Disney's legal team so feared by small businesses. They don't pick their battles based on size. They pick them based on principle. If you profit from Mickey Mouse's silhouette without a license, it does not matter if you're Warner Brothers or a mom running an Etsy shop from her garage. You are getting a letter. And if you don't comply, you may be getting a subpoena. Here's where it gets even more interesting. Because in January 2024, something happened that should have ended Disney's grip on Mickey Mouse forever. The copyright on the very first Mickey Mouse cartoon, Steamboat Willie, expired and entered the public domain. For the first time in 95 years, anyone could legally use that specific early black and white version of Mickey Mouse, the big-eared, rat-like design from 1928, without paying Disney a cent. You'd think Disney's lawyers would step back. They didn't. In 2025, Disney sued a jewelry company for incorporating the Steamboat Willie design into its products, arguing the company was trying to pass its merchandise off as official Disney-branded goods. A trademark claim, not a copyright one, since trademarks on the character's likeness in commerce never expire the way copyrights do. Then, a personal injury law firm, Morgan & Morgan, ran into the exact same wall when it tried to launch a national ad campaign using the public domain Mickey, and had to preemptively sue Disney just to get a court to confirm the campaign didn't violate any remaining Disney rights. This is the genius and the fear factor behind Disney's legal strategy. Copyright expiring does not mean trademark expires. Disney still owns trademarks on Mickey Mouse's use in commercial branding, character likeness, and merchandising. And trademarks can be renewed forever as long as they're actively defended. So even when the public domain door opens, Disney's lawyers are standing right there, making sure you understand that walking through it is still a legal minefield. Now, let's talk about the fight that's happening right now. In 2026, and it might be the biggest one yet. In June of 2025, Disney joined forces with NBC Universal and DreamWorks to file a massive copyright lawsuit against Midjourney, one of the most popular AI image generation companies in the world. The claim? Midjourney's AI had been trained on and was actively reproducing copyrighted characters. Disney and Universal characters, specifically, essentially turning a subscription AI tool into what the lawsuit called a virtual vending machine for stolen intellectual property. This lawsuit marked the first time major Hollywood studios directly sued an AI company, and legal analysts immediately flagged it as a landmark case that could define how copyright law applies to generative AI for the next decade. Disney and its co-plaintiffs are seeking an injunction that would force Midjourney to build in copyright protections before it's even allowed to keep operating its image generator. Think about the scale of that ambition. Disney isn't just protecting Mickey Mouse from a daycare mural anymore. Disney is trying to reshape how an entire multi-billion-dollar emerging technology industry is legally allowed to function. That's not a legal department. That's a legal department acting like a legislature. But here's the part of the story that gets left out of almost every "Disney's lawyers are unstoppable" video, because it complicates the narrative, and complicated narratives don't always go viral. We're telling it anyway. In 2022, Disney publicly opposed Florida's parental rights in education law. Critics called it the "Don't Say Gay" law. Governor Ron DeSantis and the Florida legislature responded by stripping Disney of its 55-year-old special governing authority over its own land, the Reedy Creek Improvement District, and replacing its board with DeSantis appointees. Disney's legal team went to war. In April 2023, they filed a 77-page federal lawsuit accusing DeSantis of running a targeted campaign of government retaliation in direct violation of Disney's First Amendment rights. And in January 2024, a federal judge threw the case out. U.S. District Judge Alan Windsor ruled that Disney couldn't prove the new oversight board had actually harmed the company because of the governor's appointments, and that the legislature had the authority to restructure the district regardless of motive. Disney's famously feared legal team, the same lawyers who'd beaten underground cartoonists, small businesses, and were about to take on Silicon Valley, lost to the state of Florida. The case was eventually resolved outside the courtroom in a settlement tied to a $17 billion development agreement. But the federal lawsuit itself was a defeat, which tells you something important. Disney's legal reputation isn't built on being unbeatable. It's built on being relentless. They don't win every fight. They just make sure that every single person who considers fighting them knows exactly how long, how expensive, and how exhausting that fight is going to be, win or lose. So, the next time you see a Disney logo, a Mickey silhouette on a t-shirt, or an AI-generated image that looks a little too familiar, remember, there is a legal division in Burbank that has spent over 50 years building a reputation most Fortune 500 companies would kill for. The reputation of a company you simply do not want to test. That's the power of corporate law when it's wielded with total consistency. It's not about winning every case. It's about making sure the world believes you will. Corporate power isn't just built in boardroom deals. It's enforced in federal courts. This is Corporate Docket. Subscribe, and we'll see you in the next case.